discussion with you, and not a formal presentation. And moreover, I mentioned to Rick that it would be interesting for us to have his view, that he would share actually his experience with concrete cases, clinical cases, and he picked Guantanamo and death penalty cases in order to explain a little bit the work he does and he has done already in the past in the clinical context. So thank you very much, Rick. You have the floor. Thank you.
Thank you. Thank you. And welcome. I'm so glad all of you could be here today. I recognize some faces from the last couple of days talking to the clinic. And I am deeply grateful to Professor Hennebel for his invitation to be here. It's a beautiful city. You all are very lucky to be here, I think. And it's a great time of year. And my wife is visiting lavender fields as we talk this afternoon. So taking advantage of the local tourism. I'm going to talk today about the work that my students have done with me that actually covers a very long period of time. Our International Human Rights Law Clinic at American University in Washington, D.C. has been open for 25 years this year. And we have worked on the topic of the death penalty almost from the time that we opened. So some of the cases I'm going to point to today are cases that go back into the early 1990s. Cases that all of which students have been involved in one way or another, and I will talk a little bit about that. For those of you who aren't acquainted with the idea of a clinical program in law, the term comes from medicine, as the name implies, and suggests that clients or customers or partners come to the clinic seeking some kind of help with a real problem in the real world. Not an abstract theoretical problem, but a real problem that needs to be solved with a client who is having some kind of a legal problem. So our students, at the beginning we were 6, now we average about 16 students per year. They are about your age. They go to undergraduate school in the United States University for 4 years and then go to law school for 3 more years. So they've all had a good deal of school. They probably are about 25 average, I would say, is their age. And they come into the clinic toward the end of their legal education. So they've had some courses that prepare them for clinic, but this is a unique experience for them in law school. And in part, that's exactly what we want it to be. We want it to be something that is unusual and something that they haven't seen before in their legal education. So something that offers them a gateway, if you will, into legal practice. Because our assumption in the United States is that most of our students will practice law. They will be advocates. They may be prosecutors, they may be judges, they may be government employees, but they are most likely to be advocates in the courts. And so we try to prepare them for that step from the formal theoretical legal education to practical legal education during the last stage of their time in the law school. Just as doctors go through a period of residency in a hospital under the supervision of a doctor, and some of you may have been in a place where you see students talking to doctors about how they're going to, what diagnosis they have for a patient, what they suggest to the doctor, and the doctor says, yes, good idea, or very bad idea, I think that's not a good solution, let's think about another solution. Exactly what we do in clinic. Exactly what we do in clinic. From the first week, the students have cases, they work on real problems. And the 2 situations I picked to talk about today, I think are important because they deal not with human rights out there in the outside world, in an exotic country in trouble or in transition somewhere in the world, but the United States itself. And the United States, as many of you know, is exceptional. It's exceptional in good ways, and it's exceptional in bad ways. The ways I'm going to talk about today are the bad ways. So they are, in my view, an effort to expose students to the reality of human rights practice in one's own country, but through the use of both the domestic courts of the United States using principles of international human rights law, and then international tribunals, to the extent that we have access to them, to petition against the United States for its inattention to these issues of human rights. And the death penalty over time, and Guantanamo since 2002, when the first detainees began to appear at Guantanamo after the United States invaded Afghanistan after the attacks of 9/11, are two of the best examples I could think of to make concrete the work that we do with students. So, except when I describe it otherwise, everything you see today has the footprint, if you will, of a student involved. Student teams, students have worked on this case, students have appeared in court, students have appeared before the Inter-American Human Rights Commission, which sits in Washington, D.C. It's a blessing in a sense that the Organization of American States, which has the Inter-American Human Rights System as part of it, has its commission headquarters in Washington, D.C. So we can go just down the street and raise a human rights issue in the Americas. So that's a blessing for us. And we use the commission a lot, and a lot of the litigation I'm going to talk about today is focused on our work in the commission. So that's the roadmap. I'm going to talk about the death penalty first, and see if I can't sort of frame up the work of the clinic and give you some concrete examples of how that work has played out in the death penalty, and then move on to Guantanamo, and then I hope leave some time, ample amount of time, for you to ask questions, raise your concerns, hear any issues you may have about the kinds of issues that I am raising. So, this is a summary, and I hope those of you in the back can see this, of the work that we have done, and it actually isn't all of the work, but it's the primary cases that we've been involved in that involve the death penalty in the United States. One of the first cases was an amicus brief, that is a friend of the court, where we go into we're not part of the litigation, but we support a particular position taken by one of the parties in the litigation as a friend of the court on behalf of the defendant in the U.S. Court of Military Appeals. The defendant was James Murphy, charged with the death penalty by the U.S. military. He was married to a German woman, had children in Germany, and left the U.S. base that was protected territory of the U.S., entered Germany, murdered his wife and children, quite gruesomely, and then returned to the base. Germany, as you all know, has no death penalty because it is part of the EU, part of the Council of Europe, and as a participant in the European human rights system, has abolished the death penalty for all purposes. And that, in my view, is a step in the right direction. It's a step the United States should be contemplating, but hasn't until now. So, we've filed a brief on behalf of Mr. Murphy, arguing that Germany surrendered jurisdiction to the United States inappropriately when it could have argued against the death penalty before rendering Mr. Murphy to the United States. It was quite an interesting case. I recall, because we went into the U.S. Court of Military Appeals. I'd never been there before, everyone was dressed in their military uniforms, except for us. We were dressed in civilian clothes, and the student who argued the case was a woman wearing a pink suit. And when she stepped to the podium, it was quite eye-catching. She got a lot of attention. She was scheduled to argue. They gave us argument on our issue of the jurisdiction of the court. She was scheduled to argue for 10 minutes, and they kept her on her feet arguing for 45 minutes. They were very interested in the issue. They did not decide the case on that basis, but they did reverse Mr. Murphy's case and sent him back for reconsideration as to whether or not the death penalty was the appropriate sentence. So we considered it a win. These cases in the second group are all cases over the years, starting with 1992 and up to the present, 2 cases now, that involve various cases from the United States involving the death penalty, and I have a little bit more detail on them in a few moments. 1 from Utah in the West, 2 from Texas. Texas is a state that is very fond of the death penalty. Florida and Ohio. Those are all cases, some of which have been completed in the Inter-American Human Rights System, 2 of which are still pending and underway. I've also done a good deal of work with the EU as counsel for the European Union in the United States Supreme Court as a friend of court. These are largely my own work, but they are also done with student assistance in the research of the case, and probably represent the most significant victories against the death penalty in the United States. The 2 cases are Atkins versus Virginia, a case that struck down the death penalty for anyone who suffers from what we would call mental retardation, that is, mental disability that reduces your IQ to below the level of 70, is oftentimes the legal definition. It struck down the death penalty for those individuals, and later in 2005, in Roper versus Simmons, struck down the death penalty for all children under the age of 18. In both of those cases, the court majority cited with approval the brief of the European Union as representative of the views of what they called the world community, the community outside of the United States, watching what is happening in the United States. Most dramatically, in Roper versus Simmons, they noted that only about 5 countries in the world continued to execute children, so that even though the United States had a number of states that were killing children, no other countries of the world other than Iran, Pakistan, some countries that we didn't like the particular being part of the company with them, were still carrying out the death penalty against children. So these were very influential briefs, and difficult to persuade the European Union to get involved in. This was at a point where it was thought to be diplomatically difficult to weigh in a legal system of another country and say, we believe this is what you should do with regard to this legal issue. So now they feel quite comfortable doing it, and I'm actually representing the EU in a case, another case that's working its way through the system that has to do with people with serious mental illness, not disability, but mental illness that should prevent them from being executed. So that's an overview. The cases, this gives you a sense of how the death penalty is carried out in the United States. In the US, the death penalty is a state issue, largely. And you can see that the states that have the death penalty, the ones in brown, are largely in the West and in the South. 65% of all the executions occur in these states: Texas, Oklahoma, Arkansas, Florida, Virginia. So, they're very enthusiastic about the death penalty. And most of the cases without The states without the death penalty are in the north and east. We have a new member of that club of states without the death penalty. Nebraska just abolished the death penalty a few months ago. This shows the states that carry out executions. It's another version of the slide I just showed. 82% of the executions in the United States occur between Texas and the border of the Old South. And I don't think it's a coincidence that this roughly calibrates with the South during the Revolutionary War in the United States and the North in that same battle in the 1800s. The death penalty is a racial issue in the United States. It is an issue that people care about in part because many of the defendants on death row are African American or other minorities. 6% of the executions are carried out in the West, although California has one of the largest death row populations in the United States, but they rarely carry out an execution. They like to impose the penalty, but not carry it out. And that's where my next slides take you. They show death row populations by year. This is 1,000, 2,000, 3,000 people, men and women. 1968, well below 1,000. We have the Supreme Court abolishing the death penalty in the early 70s, so the death row population plunged, and then they reinstated the death penalty with a different court in 1974, and the slope goes steeply up, well above 3,000, about 3,600 as of 2004. And we can see a little bit of the slope going back down again more recently. But compare that number, 3,600 on death row, with the number of executions that are carried out in the United States. This is 20, 40, 60, 80. This is 1985. This is 2013. So you can see in 1999 we had a peak of the number of executions just below 100. So if you go back to this graph, the number of people who have been sentenced to death, and put the one on the next page below it, that would run along the bottom here, something like this, way down below. So the curves are diverging. The number of people sentenced to death far outstrips the number of people who are actually executed. And I think that demonstrates an ambivalence on the part of the American public, an ambivalence on the part of judges to carry out the death penalty, an ambivalence on the part of governors to sign the warrant that says execute this person. It's harder and harder to get the legal momentum going to carry out executions. And public opinion has shifted in the United States from a peak around this period of time to today, so that now just over 50% of the US supports the death penalty, higher in those states where it is used frequently. And you may have seen the cases that are most dramatic, the cases of the shootings, for example, in South Carolina last week, of the black members of a church by a white man, a young white man, and immediately we had the governor of South Carolina saying this man should be subject to the death penalty. We saw it with the attacks in the Boston Marathon. Tsarnaev, the young man who was recently sentenced to the death penalty because of his involvement in the deaths of many people. So there is still strong public support for it in particular contexts, but it is diminishing. And our clinic likes to play a role in changing that situation. Most of the people who are executed are white. This is a pie chart that shows who is executed and who is not. 763 executions of white people, men and women, 465 black, but that is not in proportion to their membership in the population, where blacks make up about 13% of our population, but a much higher percentage of those who are sentenced to death and who are executed, in fact. So, what are the cases we've been involved in? This is William Andrews, a man charged with, again, a fairly difficult homicide, a killing that was referred to as the hi-fi murders because it happened in a high fidelity, we don't even use that term anymore, a place where they sell record players, old phonograph machines. He and another African-American man entered and carried out the killings of a number of people in conjunction with a robbery. So there were about 5 or 6 deaths. He pursued every possible appeal he could in the United States. Amnesty International undertook his case as an issue in an international arena, and they came to us in our clinic about 5 days before he was scheduled to be executed in Utah and said, "Can you help us try to stop this?" And I had opposed the death penalty for a long time, worked as a criminal defense lawyer against the death penalty in my practice, so I said, we'll give it a try. And we filed something in the Inter-American Human Rights System in 1992 to try to stop his execution, something called precautionary measures, an effort to try to slow down or stop the process when someone's life is at risk during the time that the commission is reviewing the case. We asked for it the day after we got the case. The next day, they issued precautionary measures to the United States, said, please do not carry out this execution. Utah ignored their request, and 3 days later, Mr. Andrews was executed. His case did not die with him. After he died, we amended the complaint of his case to say that it was improper for them to have executed him and that the execution itself was a violation of his human rights. The interesting part about this case, the case was decided in 1996 in his favor. Of course, one could argue it does him little good if he's not alive anymore. We have dealt with this issue in a number of these cases, and obviously the question of winning a case when there is no possible outcome that's favorable to the defendant himself is a question we all have to ask ourselves in human rights. Is this vindication? Is it vindication on principle? Is it vindication without a remedy? Does it really do any good? My view is it does all the good in the world. To say the United States is accountable, there is a framework in international law that holds them responsible for this, and that what they did is wrong. Whether or not they recognize it is another question. But there are many, many court decisions that find somebody wrong without being able to vindicate the actual reparation of that individual through either money or return to the situation before, or any of the kinds of remedies that we think about in law. So, that's an issue we could debate. The napkin incident is what got this case its international attention. During the deliberations of the jury in Mr. Andrews' case, the bailiff, the man who watches the jury outside the door, came to the judge with a note written on a little piece of paper. It was a napkin. And the note said, "Hang the niggers." It had a little stick person on it with a noose around the neck, and that's what it said. It came out of the jury room. Somebody in the jury room had it. He took it to the judge, handed it to the judge, and said, this was in the jury room. The defendant's lawyer said, we call for a mistrial or questioning the jurors about where did this napkin come from? Who wrote it? Who said it? Why are they saying it? the judge said, no mistrial, we're going ahead, and simply admonished everyone to pay no attention to these ridiculous kinds of communications. Nothing more. That was sufficient to guarantee his conviction in Utah. He lost every appeal, including an appeal to the United States Supreme Court, where Justice Thurgood Marshall, the first African-American judge on our U.S. Supreme Court, said, "This, to me, is a perfect example of lynching justice." Lynching, the process of taking someone out of the door of the prison, hanging them from the nearest tree because you believe they are guilty. But he was in a minority, so they didn't review the case. The Inter-American Commission on Human Rights found this to be both a violation of his right to life, but also, importantly, an incident of violent racial discrimination. Serious racial discrimination. And I think they were correct about that. In doing that, they cited, by the way, to a couple of cases from the European Court of Human Rights that were quite similar, that had to do with racial incidents in the deliberations of bodies of individuals deciding cases in Europe. So we used European law a good deal in that case. This is Calvin Burdine, the second case we had. Calvin is gay, was sentenced to death, and his case became known internationally as the sleeping lawyer case. He had a public defender, and I was a public defender myself. I can guarantee you I never slept during a trial. His public defender slept for a good deal of his trial, by all accounts, including during arguments from the prosecution, much of the testimony from all the witnesses. The lawyer was sound asleep. Did he lose because of that? No. Convicted all the way. In fact, the prosecutor made arguments about his being gay. Homophobic comments about him being a gay man and probably deserving the death penalty more than others because of that. Didn't provoke any response from his lawyer, didn't provoke any response anywhere along the way. Texas courts, perfectly happy. So we filed an action on his behalf, but this was in 1994. And I will tell you, at the time, we focused on the sleeping lawyer, not on the gay. Why? Because at the time, in the Inter-American Human Rights System, the members of the Inter-American Human Rights Commission were almost all from Central and Latin America. And at that time and period in our history, tolerance for LGBT issues was very low. Being gay was not a good thing. So we kept gay out of the picture. Today, the Inter-American Human Rights Commission has a special rapporteur on LGBT issues. It accelerates consideration of LGBT cases, but this is a giant change in the community of human rights over a very short period of time, 1994 to today, so about 20 years. Changed completely the attitudes about issues about gay individuals and the protection of LGBT community as minority. The case ultimately was resolved in the state courts, not in the Inter-American system, and Mr. Burdine was eventually sentenced to a plea, on a plea of guilty to life imprisonment without parole. He said he was quite relieved to have the death penalty off the table, and as far as I know, he continues to live in prison, serving out his sentence. Not because of what we did, but because of what happened in the state courts. This is a young man whose name, before he changed it, was Gary Graham. He converted to Islam and changed his name to Shaka Sankofa. He was 18 at the time of his conviction. He was executed some 20 years later at the age of 37. So he spent all of those years on death row in Texas. His case had to do both with that issue, the long time on death row, and with the inability to gain access to the courts in Texas to review his case, because they barred him from pursuing any kind of attack on his conviction under state law. And again, we prevailed in this case, but Mr. Sankofa was executed during the process of our consideration of his case. Students argued these cases in every single situation. So, before I go on to the Guantanamo work, let me summarize. In every one of these cases, and probably William Andrews is one of the best examples, the very first case I talked about from Utah, we had about 3 hearings in the Inter-American Commission on Human Rights, where we would sit in a room and the students were on one side, the government of the United States on the other, arguing about whether or not this is a proper sentence, whether or not there was discrimination, what was going wrong, and the US government engages in the process. They engage in the process. They just don't respect the outcomes. So, they argued against us, and we had hearings. They brought witnesses. They brought the Attorney General of Utah. They brought other witnesses. The students were able to question the witnesses. The students did all of the work. So there is no rule in the Inter-American system that says you have to be a lawyer to argue here. It says anyone can petition. Anyone can petition. So the students do the arguing. Same was true in all of these other cases. The Guantanamo work, and we'll move on to that, and I'll finish with this part of the talk, is a bit different. I want to say at the outset that when we took the Guantanamo case, Omar Khadr's case is the most prominent one, and I'll talk about it in greater detail. We took it in part because the United States Supreme Court said no one can be kept in a law-free zone. The people who were incarcerated at Guantanamo, held at Guantanamo as detainees, the government argued had no legal rights. They had no legal right to any access to any court anywhere. That was the position of the United States government. They're not in the United States. They're under our custody and control, but they have no access to the U.S. courts. They aren't in the U.S., they're in Cuba. And they don't have access to any other tribunal because they are not prisoners of war. They are just our captured detainees that we can do whatever we want to with. That was not a position that fared very well, as I will talk about. And of course, we were very, very concerned about this at the time it happened. We were talking at lunch about what happens after major attacks in a country and how public opinion shifts so radically. Your experience with Charlie Hebdo and the attacks after it, and the way the public consciousness changes, and the way we become more paranoid, we become more frightened for our rights, and what do? We sacrifice our rights. We say, take our rights, state, protect us against terror. This is what happened in Guantanamo. This is what happened in the United States after the attacks of 9/11, and particularly for those individuals who were Muslim, spoke Arabic, came from the same population as the individuals who carried out the attacks. Right? So, this is something that we tried to pay attention to. We said we wanted to be involved in these cases right from the beginning, and we decided we would. Later, a colleague of mine who teaches at Seton Hall University near New York City wrote an article saying that cases involving Guantanamo are the best kind of clinic case and the worst kind of clinic case. And I agree with him on both counts. Why are they the best? Well, because it's a national crisis. It's something we can be involved in that attracts everyone's attention, everyone is concerned about, and everyone is, I hope, particularly concerned in the human rights community with protecting the rights of individuals who are in detention. It is the worst kind of case because it was very difficult for us to have students involved. From the very beginning of our involvement in these cases, we were told students couldn't have access to files, that they were secret, that only teachers who had security clearances at above a secret level were allowed to have access to those documents, to review those documents, to visit the base in Cuba, to talk to these individuals, and if we did talk to them, everything they said to us had to be screened by the Pentagon before it was released to us or to the public or certainly to students. So it became an incredible uphill battle to try to just get information about cases. And only the professors could go to Guantanamo. I did that about 13 times over the period of time that we represented these individuals. A student was never able to go with us. So it wasn't my model of a clinical case, where my preference is to have the students be in charge, have the students be out front, have the students gathering the information, but this wasn't to be in these situations. So here's the work we did. First of all, in the Inter-American Human Rights Commission, I'll talk a bit about precautionary measures. You remember I just mentioned them before. That is, using this means of intervention early in a case to stop the proceedings if possible, prevent further harm to the individuals during the consideration of a case, on behalf of all detainees before any names were released to the public. This was in 2002. Later, we filed for precautionary measures and obtained them for Omar Khadr, a citizen of Canada, who was taken into custody early in the time of the intervention in Afghanistan. We also represented Omar Khadr in federal court in the District of Columbia, number of emergency requests for relief because he was 15 at the time he was captured, a child. We argued if he was a child soldier, there is international law that deals with child soldiers that says they should be rehabilitated and reintegrated into society, not treated as prisoners or held with adults. To no avail. Nobody listened to those arguments. We also represent and continue to represent a man named Salem Garebi from Libya. His case has been dismissed in the federal courts at his request. I did not include in here, and should have, that we also represented Omar Khadr in military commission proceedings in Guantanamo. He was charged with murder, with other crimes, because during the time of his capture, an American soldier died. And I think that's why he had such a difficult time with his case. His case was one of the very few where there was at least a factual question about whether or not he was involved in some kind of criminal activity. So his was a difficult case. There's a slide about that I will come to in a moment or two. We also, after President Obama was elected, he created an interagency task force of the Pentagon, the State Department, the Justice Department, all of the relevant departments, to review every file of a detainee at Guantanamo to decide if they were really dangerous. And we took 2 cases to that interagency task force, and students prepared a dossier, a file, to argue that our clients were not dangerous and could be released. And we won both of those. They determined that Polat Sirajov from Azerbaijan and Salem Garebi from Libya are cleared. They have been involved in nothing that is of concern to the United States. One of them was released to Slovakia. The other continues to be detained at Guantanamo because he can't find a country that will accept him for transfer. So, everyone in the government says he has done nothing, but he can't be released in Cuba, he can't be released in the United States, he can only be released to a third country, and no third country has agreed to accept him. And finally, we published a report, co-published with a couple of NGOs in DC, called Indefensible, in which we set out definitions of what constitute war crimes by the administration, by the CIA, by others involved in these cases. This report is available on our website. We argued that it's quite a hefty report. We sent it to the Justice Department. We sent it to every member of Congress. To date, nothing has happened. You may have seen that the Senate released a report having to do with the CIA's involvement in torture last year. That gave a ripple of interest, but thus far the Obama administration has expressed no interest in prosecuting anyone from any prior administration for any wrongdoing involved in either torture or other war crimes that may have been committed by people in our own administration. So we offered this as evidence of their eligibility for prosecution. This is the mission accomplished paradigm. This is our President Bush declaring victory in 2003. Needless to say, the victory was not very long lasting. It's still going on today. This was the victory over the Taliban in Afghanistan. Query whether we have won that fight. Mission accomplished was the paradigm. No, it was the argument made by the government that we prevailed. And in part we prevailed by using Guantanamo. This is a map of Cuba. Guantanamo is the little square down here. This is Miami in Florida. It's a very short hop, 90 miles from here, from the tip of Miami to Cuba. But to get to Guantanamo, you have to fly all the way around Cuba and come up underneath it. It takes about 3.5 hours in a small plane, because you can't fly over Castro's island if you're from the United States. So you have to go outside, come up underneath, and land over here on this side. The lawyers stay over here, the detainees are held over here. This area is a military base. And when you go across the bay every morning, you take a nice, pretty ride in a launch. You come out, you get off of the launch, you get into a bus, and what's the first thing you see? What do you think? Starbucks. Starbucks. Then you see a McDonald's. Then you see Kentucky Fried Chicken. Then you see Domino's. Then you see, name the brand. It's all there. It's like you're driving into a Midwest town in a desert somewhere. But you're driving very slowly, because you can't drive faster than 25 miles an hour because you might run over an iguana, and iguanas are protected species. Not the detainees, the iguanas, as somebody noticed during oral argument in the US Supreme Court. The iguanas are more protected than the detainees. So, the visit over to the detainees is quite a trip. Getting in to see them is an incredibly long process involving searches, long, looking through everything you have, questions, wearing a big badge that says habeas on it, meaning you are a lawyer seeking habeas corpus, the release of these individuals. Doesn't make you very popular among the military personnel there. So, this is Guantanamo. In 2002, when none of the detainees were known, we asked for precautionary measures. I mentioned that to you. And we, at that time, was a number of NGOs, including the Center for Constitutional Rights in New York City, which had the lead on these issues, Amnesty International, Human Rights Watch, a number of other groups, and our clinic as well, sought protection for these unnamed detainees. And I include this language because it is so close to the language we're going to see from the US Supreme Court 2 years later. It basically says that no person who is under the authority and control of a state, regardless of his or her circumstances, is devoid of legal protection. In other words, there is no such thing as a law-free zone. Human rights apply everywhere, they said. The law of armed conflict may apply in addition, they said, and they say so here, but human rights always applied. This was not a recognized concept. It's an argument that the United States continues to make. They continue to argue that the law of war trumps human rights, and only the law of war should apply, and human rights law doesn't apply when the law of war does apply. That's not an argument that's widely accepted, but it is an argument the US makes and persists in. This is the decision of the Commission. It was international news, certainly in the legal community at the time. It was unprecedented. They were talking about the law of war and human rights. Why is this international human rights body talking about the law of war? Don't they only talk about human rights? No. They talk about the law of war when it relates to human rights. So that's what they did. This is the decision in Rasool versus Bush in 2004 that said the people in Guantanamo have a right to a lawyer. They have a right to access to the courts. And it looks very similar to what the Commission said 2 years earlier. They have been imprisoned in territory over which the United States exercises exclusive jurisdiction and control. So it doesn't matter that they're in Cuba. They are under the exclusive control and authority of the United States. The base is essentially the United States territory that holds them under its jurisdiction. And as such, aliens held at the base, no less than American citizens, are entitled to invoke the federal court's authority under the habeas corpus statute. This will open the door for lawyers to be able to go. And within 3 days after this decision, we decided to take the case of Omar Khadr. This is a photograph of Omar at age 15, just before the time of his capture in Khost, in eastern Afghanistan. He was in Afghanistan. He was with his family. He was with a brother. He was with a couple of, two brothers and his father at the time in Kabul. They all fled. His mother and sisters fled across the border. He was separated from his family, and in a firefight in 2002, he was captured, and as I mentioned, an American soldier died. Bernard Duhem, who is here from Canada, I'm sure knows of the Omar Khadr case. Omar was a celebrity of sorts in Canada from the time of his capture in Afghanistan, because he is a Canadian citizen. And until his transfer to Canada, was the only person from an allied country of the United States who was not transferred to their home country, and Canada, with a conservative government, was more than happy to leave him sitting in Guantanamo during this period of time. So we undertook his representation in 2004, and it became very clear to us from the start that the only way to tell his story was not in the courts, but in the media. So we talked to as many people as we could. We eventually got this story in Rolling Stone magazine. I loved that we were in Rolling Stone. They covered his case in 2006, and the title of the article is pretty telling. Unending Torture of Omar Khadr. Had to do with his mistreatment by soldiers after his capture, his mistreatment in Afghanistan, his mistreatment during transport to the base, and his interrogation in Guantanamo after his arrival, all at the age of 15 and 16, not separated from other individuals. The cases continued, and Omar eventually went to trial in front of a military commission, as I mentioned. And this is us, me, that white-haired guy, another professor. This is Omar. These are two military lawyers who were assigned to his case. When they were assigned to and you'll notice nobody's face is showing. because they said to the reporters, you can't show anybody's face. We won't let you draw anyone's face. So the judge's face is off in the background there, but not really too clear. And this case was his first appearance when he was charged with murder. We already represented him, so we stayed on his case, but they required that he have 2 military lawyers. We had 2 men who joined us, a colonel from the Marines and an Air Force captain. They turned out to be absolutely fantastic lawyers. We loved working with them. They were very good. And immediately after he was charged, the commissions failed. They were found unconstitutional by the U.S. Supreme Court in a case called Hamdan in 2006. Struck down the entire system of military commissions. That didn't stop the United States from carrying out military commissions trials. They readopted the law within 6 months. A new commission was created to meet constitutional scrutiny, and the military commissions continued. We stopped representing Omar in about 2007. The military lawyers continued on his case. He got Canadian counsel to represent him, and he was well represented during the process. The publicity continued in his case. This is a book about Omar. It covers in a couple chapters the work that we did through the clinic on his behalf. And I might mention that the work that we did in the U.S. federal courts was work where students could appear. So I actually argued a case with one of my students in the federal court having to do with his access to medical treatment in Guantanamo, urgent medical treatment, and another one about his torture and his possible rendition, his being transferred to another country without using proper legal process. The students prepared those briefs, argued those briefs, along with me in federal court. So they were involved in his case in the legal sense, but that was not an easy road to go. This is a documentary as a result of a release of tapes in Canada. You can see these were taken through an air duct. This is an air conditioning duct. It has the ventilation fan here. This is Omar sitting in a chair. And the documentary was called You Don't Like the Truth, 4 Days at Guantanamo. It's about a visit to Guantanamo by Canadian individuals who represented themselves as his friends, as representatives of the consular service that everyone is entitled to in international law, to be advised of their rights and to be helped with managing the legal system. It turned out they were actually agents of the Secret Service and the intelligence services of Canada, gathering information about his case, and sharing it with the U.S. government at will. The Canadian courts ordered release of these tapes. They were made public and made into a film. They show Omar, still quite young, crying, describing the situation there, and when they said, "Tell us the truth," he said, "You don't like the truth," and I think he was probably right. I had to include this. This is a statement by a military commissioned prosecutor, a man who was involved in the prosecution side of these cases. He was involved in the prosecution of another young man, Jawad, from Afghanistan, and he resigned from the case. He said, "I think it's wrong for us to treat children in this way. I'm a resolute Catholic and take it as an article of faith that justice is defined as reparative and restorative. He should have been segregated from the adult detainees and some serious attempt made to rehabilitate him." That is exactly what the international law says. Separate the children, rehabilitate. He agreed. He quit rather than continuing to prosecute an individual child. Not everyone was as brave as this man. This is a picture of Omar at the time of his capture and at the time of his plea of guilty at age 23 in 2010. He grew up at Guantanamo. He became a man. He's taller than I am now. He's about 6'4", big guy. He pled guilty to murder and other charges. The official press release from the government says that he was sentenced to 40 years confinement as a result of the jury in the military commission for violations of the law of war, including murder, attempted murder, conspiracy, providing material support for terrorism, and spying. All of those charges. He says, today, I only pled guilty to get out of Guantanamo. I didn't do what I was accused of doing. I either can't argue with that or won't argue with that. I can't argue with it because I've had confidential conversations with him, which I can't share. And I also won't argue with it because history will decide eventually, I hope. But he did plead guilty. He admitted his guilt of this crime of the death of the American. In fact, it was not 40 years that he actually got. That's what the jury said. But the plea agreement said he would serve 8 years in prison. No credit for the time he did in Guantanamo. Eligible for transfer to Canada in 1 year. He was transferred to Canada in 2012. He was kept in a minimum security prison in Edmonton, Alberta, for a long period of time, and was released last month at age 28. This is a picture of Omar in freedom. Finally, I think the most telling thing about his case, the place where his being a child mattered the most, was in the actual sentence that he received. If he was guilty of murder, he was sentenced to only 8 years. That's not a long sentence for a murder. It's a kind of sentence that a child would get in Canada or the United States for a similar crime. So if his childhood was ever considered, it certainly wasn't under international law, it probably helped in his obtaining his freedom eventually. And let me just quickly finish with just a quick shot. This is Polat Zarajov from Azerbaijan. This is a picture before he went into custody that his family gave to us. He was taken in by warlords in Afghanistan. They got a bounty, about $5,000 for him. Happy to take that. Turned him in. He was considered an Arab in Afghanistan. That was enough to get you transferred to Guantanamo at the time. He's not Arabic, but he looked Arabic. So he was transferred to Guantanamo. This is him in Guantanamo. These pictures, incidentally, come from where? WikiLeaks. We didn't have these pictures. These pictures were published on WikiLeaks when they got all the pictures of all the detainees at Guantanamo and put them all up on the internet. It was great. They told us for a while we couldn't use these because it would violate national security protocols. Well, that was crazy. No way, you can stop it. They're out there in the public. They're too bad. So, this is him with his beard. He shaved it off, moved to Slovakia. I understand he's getting married to a Slovakian, so he obviously must have learned Slovakian. And he seems to be quite happy living there. This is Salem Garebi before his detention. This is actually probably a pretty young photo of him. He's now 52, taken from a bus in Pakistan. He's married. His wife and 3 children are in Pakistan. He hasn't seen his youngest child. She's about 7 now. This is him. He doesn't look happy. He is cleared. He's ready and waiting for transfer, but he's not a happy detainee. And when he has conversations with anyone about anything about his case, he tends to be fairly grumpy. So he doesn't talk happily about being transferred anywhere. So he probably has done himself some damage in putting on a happy face and trying to convince people that he will be a good citizen when he's released. I don't think he's a risk. I think he wants to get back to his family, but he's angry about his detention. So, this is a picture of the cover of the report that we did called Indefensible, a reference for prosecuting torture and other felony crimes committed by U.S. officials following September 11th. Done by the Human Rights USA, our clinic at American University. So, I think I'll stop there. I've been talking for a long time. And open the floor for your questions. I imagine you have some. Let me say, in anticipation of a question I oftentimes get about representing Omar Khadr, I was a public defender for a long time, and I represented people charged with murder, convicted of murder, convicted of other serious crimes. I never asked, are you guilty? Because I don't think that matters to me. It's not an issue that I'm concerned about. It doesn't make any difference about whether or not I have to represent them or not. I still have to represent them, even if they are. And if they tell me they are, I'm not sure I believe it. Maybe they don't know. Maybe they don't know the legal definition of what constitutes murder. Maybe they feel guilty about it, but they aren't guilty legally. So it's irrelevant. And it's irrelevant here. That's my view. I don't know what you all think, but that's my view. All right, let's hear some questions. Fire away.